This is the beginning of disc number 3 in the deposition of Dr. Shank. The time is 3:07 p.m.
Doctor, we don't need to go over all the opinions that you've already given so far, but what I need to know now, do you have any additional opinions that you now have and or intend to give in this case? I would like to know what those are, and I also need to know all the factual basis for those opinions.
Sure. I don't have anything that I think is particularly substantive. I think we've covered it well today. The only other thing I would want to mention, it flows pretty naturally, I think, from what I've testified to, but specifically I don't think there was any necessity of having any consultancy the patient or for the patient to be admitted to the hospital. And I don't know that I definitively stated those, although it would flow naturally from what I have said. I also thought that the arrangement for his follow-up care to be rechecked in 1 or 2 days, being specifically given 2 different orthopedic practices he could follow up, was very appropriate and reasonable.
Anything else?
That's all I can think of.
Okay. Do you have, are you of the opinion that Mr. Tolson either contributed to, caused, or did anything, or failed to do anything that caused or contributed to his injuries?
Objection.
The only thing that comes to mind in that regard, and I do not know exactly what is contained, is whether or not that he was walking in an area that he was restricted from and not supposed to be walking to start with. I have no idea if that's the case, if not, or if he was cutting across a parking lot where this barrier was that was restricted to foot traffic. I don't know. When I read through his deposition, I couldn't tell. I know he went back and took some pictures when he wasn't supposed to, but I couldn't tell for sure if he was not supposed to have been walking in that area to start with. So I don't know. I simply tell you that there's that possibility. If he was in an area where he did not belong, you were not supposed to be walking because of the hazards, then obviously there's something there that would relate to his activity. If that is or is not the case, I do not know.
Usually in medical malpractice cases, a patient's negligence is usually, as a defense to a case, is usually confined to him delaying in getting medical treatment, not following the advice of his doctors, not following follow-up care, or doing something completely out of the ordinary once, in this case, once he gets to the hospital. So I want to know, from the time he got to the hospital till today's date, are you of the opinion that he did or didn't do anything that caused or contributed to his injuries?
I think we all understand the question, but I'm just going to object to your recitation of the law. Go ahead.
I do not find any evidence that he did anything after he was seen in the ER that he contributed to any injury. I know there was a question about whether he took the splint off or not. I never could figure out if he did or didn't take it off. I'm still not sure if he took it off. Certainly if he took that off, that would have been inappropriate to do so and could have either exacerbated or caused arterial injury because of the instability of the knee. But I don't know if he did or didn't, and I prefer to address it in that context. If I knew for sure, then I would say that's an issue. I don't know for sure, so I don't know if that's an issue or not, and I don't know how to resolve it because I don't have information that tells me one way or the other.
At this point, you're not of the opinion, though, that anything that he did or didn't do after December 3rd, 2009 caused or contributed to his injuries. Would that be a fair statement?
Assuming that he did not take the splint off, assuming that hypothetical from my perspective, that would be true.
Okay. Now, if he did, how would you know what activities he may have been involved in or may not have been involved in that aggravated his condition?
That would raise the question, because of the instability that we know his knee had, taking off the splint could certainly allow re-injury, more injury, some degree of injury to the vascular structures. I don't know any way to quantitate that for you. I'm not a vascular specialist, and I wouldn't attempt to. I'm just saying that it makes rational sense, knowing what happens with joint dislocations and knowing what happens with significant knee injuries, as he subsequently was shown to have, that if he indeed removed that splint, it would be very reasonable to think it could have further injured his leg. In terms of having an absolute objective basis to provide that opinion to you, I do not have such.
And you would not be able to provide an opinion as to what extent, if any, that activity would have aggravated his condition, because you're not a vascular expert, correct?
Well, sort of true. I don't think anybody could tell you how much was original and how much was re-injury if the splint was taken off. That would be an unquantifiable event because there would be no way to separate those two things out. So I don't think a vascular surgeon can, or an orthopedist or an ER doctor. I can tell you I would not attempt to do so because there is no logical, objective way to separate two different events out. The one thing that does intrigue me a bit that we didn't talk about today, but I'm happy to chat with you about it, is the fact that when he left, his pain was 0. If he was having ischemic changes at that time, and this does go to the heart of some of the opinions I gave you earlier, I would have expected, despite the Toradol and the Dilaudid, for him to have had some persistent pain, even in the splinted form. Because ischemia is independent of movement. I mean, if it's ischemic, it hurts whether it's moving or not moving. It might hurt worse if you're moving, but it's going to continue to hurt. And so it did figure in to the reliability of that 0 pain, and that whatever injury he did have at that point in time, assuming there was some vascular injury, must have been relatively minimal, and it also fits with the fact that his neurovascular status was intact by these people. So it gives some credence to those exams in terms of them indeed verifying there was adequate blood flow to that foot. Generally, if something is significantly ischemic, while I can't say in every case, it would be unusual that if you have significant ischemia that you would go 2 days before you just wouldn't be knocking down somebody's door anywhere that would see you because of the pain that goes with ischemia. Because if you look at what ischemia causes, the first thing in every textbook is pain. Now there's also pallor and pulselessness and paresthesias and paralysis, but pain is the predominant symptom because the tissue is starved for oxygen. So that piece of it has intrigued me a little bit in terms of looking at that, and it does factor into my opinions in terms of deciding if a subsequent event and how much that did or did influence the final outcome, way out of my league.
Now that you brought up the fact that if he had ischemic changes in his leg, you would expect him to be in some sort of pain when he left the hospital, would that be a true statement?
If he had significant ischemia, again, this is on this sort of continuum thing that you have to sort of define where you are. If there were significant ischemia going on, I would have expected his pain to have persisted and not have resolved with the interventions of 1 of Dilaudid, 30 of Toradol, and splinting. And
you were aware that he did testify at his deposition that he was still in pain when he left the hospital?
Where there's a difference in the records. I place a great amount of credence in information that is contemporaneously recorded that is specifically derived from asking the patient a point-blank question, what is your pain level? I think that has a lot of credibility. I don't know, his recollection, we all have recollection bias. He obviously had a lot of things happening to him. I think an objective recordation of what transpired when nobody knew what was going to happen is a fairly reliable finding. So he may have a perception of something that's different than what was recorded.
Dr. Sarkar addressed the percentage of the loss of flow in his blood at the time of discharge when he talked about the ischemic changes. Do you remember him saying that it had to be probably about 75%?
Yes, sir, I did read that.
Are you going to challenge his opinion in that regard in this case?
Relative to percentage decrease and ischemic and pain, no, sir, because that's out of my field.
Thank you. Okay. And I presume you're going to opine that Ms. Shaw did not breach the standard of care during the treatment of Mr. Tolson?
Correct.
Okay. Can you give me the factual basis for that opinion? I know we touched a little bit, but I want to go, if we can go specifically down why you believe she did not breach the standard of care.
Sure. I felt like the history that she took was adequate and appropriate, that her physical exam was appropriate for the situation, that the diagnostic studies that were done were appropriate given the preceding history and physical, that those studies did not reveal any evidence for further imaging, nor did the mechanism of injury as understood by her at that time, nor that then related by the EMS sheet indicate that any further evaluation needed to be done, that there are no injuries to the ligamentous or tendinous structures around the knee that require emergent intervention, and that providing pain medication, splinting, crutches, and prompt orthopedic follow-up is the perfectly appropriate way to proceed at that point in time.
And how about for Dr. Jackson?
similar. She's there as the supervising physician and indicates that she saw the patient with Ms. Shaw and that she agreed with the care plan.
Does it matter one way or the other that Dr. Jackson had the opportunity to check a box on the hospital form that she actually interviewed, examined, and participated in the care of the patient, but that she left that box blank?
Objection.
You know, I don't really think it makes a whit's bit of difference. She indicated she saw the patient with Ms. Shaw and that she agreed with the plan. In general, from a physician perspective, that would indicate that she's taking responsibility and agrees with what she knows and understands and has found on her physical exam and agrees with the PA, which is what most of us do in terms of a 1 or 2 line entry relative to our interaction with, and know that by doing so, then we're checking off on what they've done. Whether or not that box is checked, I don't think really matters, and I certainly don't think it's a standard of care issue. Maybe a documentation question, but I don't think a standard of care issue.
In this case, Dr. Jackson did not document the fact that document any of the findings that she said she found upon physical examination of Mr. Tolson. Did that have any bearing one way or the other on your opinion that she didn't do anything wrong in this case?
Objection.
Okay, I'm going to try to answer your question. I'm not sure I understand it. That is a perfectly common procedure in the way that physicians interact in the ER with patients, where they don't record anything other than saw with PA and agree with plan. I don't know if that answers your question or not.
Is it your experience as an emergency room doctor that when you actually perform a complete physical examination of the patient, similar to what Dr. Jackson said she did in this case, that you do not write in the chart any of your findings?
That's a difference.
I'm just going to object because, again, this is not a criticism of Dr. Jackson that I've heard from any of your experts, but you can proceed.
That's a little bit different question, and so I will tell you the very precise answer to that. My partners will do entries exactly like Dr. Jackson does. I see it all the time because I see people in follow-up. I happen to be of a bent where I am very insistent on recording my own stuff. And so on patients that I see, it is my preference. What I do doesn't establish the standard of care by any means. It is my preference that I detail my own physical exam completely.
Well, that brings us to another question. The standard of care opinions that you're given in this case, isn't it based upon how you evaluate, diagnose, and treat patients in emergency room setting as a doctor?
Objection.
No, sir, because what Dr. Shank does not establish a standard of care. What's reasonable and prudent establishes a standard of care. And on this particular issue, my partners tend to do just like Dr. Jackson did. It happens to be my preference to do otherwise, and so I do it otherwise because it's a preference issue. It's not a standard of care issue.
So in this case, though, the opinions that you provided on the standard of care are not based upon your experience in handling the 10 knee dislocations yourself?
Objection to form and foundation. You mean entirely?
See, what I'm trying to say here, maybe we're talking different things,
Yeah.
Doctor.
We must be, because I think you're insinuating that I think you are.
No, I'm not. What I'm trying to say is, for the opinions, set aside the documentation issue. Put that aside.
Okay.
I want to know, for the opinions that you've given in this case, are they based upon what you have done in your practice and your understanding of the emergency room medicine practice since 1980?
Sure.
Okay.
Entirely?
Okay. See,
Yeah, we got a little digression there about a preference issue. And it happens, and that's so, yeah, okay.
So it's based upon patients that you've seen in the emergency room, patients you've cared for in the emergency room, the evaluation of your patients in the emergency room, and what you do for your patients in the emergency room, in part.
Yeah, and knowledge and education and extensive reading that I do all of the time, and 135,000 people that I've seen. Yeah, all of that rolls into it, and also considering what a reasonable and prudent physician would do. Because my partners sometimes make fun of me for the extent of things I go to, above and beyond what I think is required to fulfill the standard of care.
I understand.
It's my personal OCD that happens to come through, and so I do it because it's a preference of mine, not because it's required.
All right. Now, when you were contacted by defense attorney Ms. Dinsmore, had you ever worked for her or her firm before?
I don't think I had reviewed a case for Ms. Dinsmore before. I have for the firm.
Do you know how many?
Over the last, I'm guessing 10 or 12 years, I've probably reviewed 10.
Have they all been for doctors?
Yes, sir.
Okay. Do you find any, did you do any literature search?
No, sir.
Okay. Do you find any medical journal, article, textbook, either authoritative or reasonably reliable for the medical issues in play in this case?
I do not, the way that you define those terms from a legal sense. I certainly find them helpful and useful and refer to them frequently.
And would one of those books be by Tintinelli?
Tintinelli, I enjoy and have on my shelf at home, as well as Rosen's. And I also have Rosen and Barkin's 5-minute consult, which I think is just a splendid little thing that cuts away the fat and gets to the meat of an issue in a hurry.
Okay. Other than the documents that you brought with you and the radiology discs, has counsel shown you anything else, or have you looked at anything else in evaluating or preparing for your deposition in this case?
No, sir.
Okay. All right. And have we covered all the opinions that you've reached and intend to give in this case?
I think so. Little did I know that that one comment would spark this conversation, but hey, it did, so I think we're done.
And have you provided me with all the factual basis for your opinions?
I have, to the best of my ability, yes, sir.
Okay, thank you.
If I discover something pertinent, I will be sure and pass it along immediately.
Thank you, Doctor.
I do have some follow-up. And I apologize if I have to skip around, but that's the nature of going second. We met Danielle Dinsmore, just for the video, Danielle Dinsmore on behalf of Dr. Jackson and Cruppershaw, PA. In talking about, you were questioned extensively about the mechanism of injury in this particular case. You agree?
Yes.
Okay. Similarly, I questioned Mr. Tolson at his deposition extensively about how this injury occurred to him. Do you recall that in his deposition?
I recall that. It went on for numerous pages, and I think I recall on one page, it seemed it was in reference to Mr. Gaston, that he had difficulty understanding it as well.
Objection.
And Mr. Tolson, you mentioned, provided us with photographs of this gate that he had taken on location, and that was at his deposition, and we were using that to try and discuss how the injury occurred. You agree?
Yes.
And even with those pictures, Mr. Tolson was having difficulty communicating to us how the injury occurred. Is that your interpretation of his testimony?
Objection.
That appeared to me to be the case, yes, ma'am.
And now, having read Mr. Tolson's deposition testimony, do you, Dr. Schenk, have any clearer understanding of how this injury occurred to him?
It was difficult to understand reading through what he said exactly how it happened.
And was his testimony at his deposition, now 4 years after the fact, different in some respects than what was documented by the paramedics in the EMS trip sheet?
It was, and the one thing I noted on page 64 where he talked about that he was caught by something between his legs sounded to me to be substantially different than stepping down into something where his foot got trapped and he twisted and fell to the ground. It sounded like a far different mechanism of injury.
And fair to say that the paramedics and the medical providers in the emergency room at St. Agnes did not document anything about him getting caught between his legs, correct?
Correct.
Understanding Mr. Tolson, even today, has a difficult time explaining how this injury occurred. Would you agree you can't fault any of the medical providers in this case for whatever conclusions they drew about how Mr. Tolson was injured?
Objection, form, foundation, calls for speculation.
Based on what I said previously, certainly miscommunications can occur. Having answered Mr. Gaston's question, I tried to stick, unless I did so and mention otherwise, strictly to a prospective evaluation of the information I was provided. So his testimony, of course, comes after that. Placing this testimony in the context of what else I knew, informing my original opinions, it became clear to me that indeed Mr. Tolson seemed to have trouble even later, after having plenty of time to think, to describe this injury in a way others could understand, and certainly helped me understand why it might be that different things were told different people at the time of the acute injury.
Okay. And nothing that you've actually seen documented in the medical record would lead you, or a reasonable ER physician or medical provider in the ER, to conclude that Mr. Tolson had dislocated his knee, correct?
Exactly, and that's what I said repeatedly. There is no mechanism of injury here that would in any way, shape, or form make one be concerned about a vascular injury on what we know prospectively.
All right, and Mr. Gaston had you go through Dr. Larson's deposition testimony and pull out testimony that you had tabbed for whatever reason. You recall that?
Yes, ma'am.
Okay. You understand that Kenneth Larson, MD, was hired by plaintiff's counsel to give standard of care testimony against my clients, Dr. Jackson and Cruppershaw. You understand that?
Yes, ma'am.
And he's testified in his deposition that Dr. Jackson and Ms. Shaw breached the standard of care. You agree?
Yes.
And did you see where his opinions were based, at least on part, in his belief that Mr. Tolson was hanging from this gate he described, flapping in the wind?
He described hanging from a gate and twisting in the breeze, I believe were his words. Okay. I think it's about page 72.
All right, and he also described that Mr. Tolson's leg was virtually torn in half, or words to that effect, correct?
It said torn from his body.
And that's pretty dramatic testimony, would agree?
I indicated earlier that I thought phrasing it in that way was a bit hyperbolic.
All right. Did you see anywhere in the medical record, or in Mr. Tolson's testimony for that matter, where he told anyone at St. Agnes Emergency Department that he was hanging from a fence twisting in the wind?
I did. Twisting in the breeze.
Twisting in the breeze.
I did not.
All right. Did you see anywhere in the medical record or in Mr. Tolson's testimony, or anyone's testimony for that matter, that Mr. Tolson told the ER medical providers that he felt like his leg was virtually torn from his body?
No, ma'am.
Now, Dr. Larson and the other plaintiff's experts were given a videotape that was created by Mr. Tolson's attorney that purports to depict how this injury occurred. Did you see where Dr. Larson was asked about that video?
Objection. Go ahead, Doc.
I saw where Dr. Larson and I think Dr. Sarkar and Dr. Malik, I think maybe all three of them were.
Okay, and you understand that video that they were shown was created by Mr. Gaston?
Well,
Objection.
I didn't understand exactly. I think Dr. Sarkar had a part in it. I wasn't exactly sure how it was all done.
Okay.
I knew, of course, that they were all involved in producing it, however.
All right, and do you understand that that video was created by Mr. Gaston, or at Mr. Gaston's direction, as a part of this litigation?
Objection.
That was my understanding.
All right. Do you think it's medically reasonable or appropriate for Dr. Larson to base his standard of care opinions on information that was never relayed to the folks who were caring for Mr. Tolson in the emergency department?
Objection.
As this case is outlined, I do not think that's reasonable to do so.
All right. Do you think it's reasonable for Dr. Larson to base his opinions on standard of care against my clients on a video created by plaintiff's counsel or at his direction some 4 years later during the course of litigation?
Objection mischaracterizes the video. Go ahead.
I don't think it's appropriate to ever base standard of care opinions on retrospective evaluation and use information that is obtained later or discovered later to then reapply to what someone should or should not have done based on the information they had. Standard of care is strictly prospective and going forward. Causation, often use stuff after the fact to talk about my opinions that might corroborate or confirm something. Standard of care is what we have and what we know at the time we know it, and is independent of and unrelated to information that becomes available later. And that would include a video of this sort that is purported to show what transpired at the time of the event, which, assuming that it shows what it sounds like it showed, is dramatically different than what the EMS people or anyone else recorded that he said happened at that time.
Okay. You were asked several questions about Mr. Tolson reporting a cold foot or an inability to feel his foot. Do you recall those questions?
Yes, ma'am.
Did you see anywhere in this medical chart or in the testimony of the medical providers in this case that Mr. Tolson reported to anybody that he had a cold foot or that he couldn't move his foot at the time of, or feel his foot at the time of discharge?
Not that was reported to any of the medical people involved.
Okay, that's all I have. Thank you, Dr. Shank.
Okay. One of the things, sort of as part of this, I need to mention somewhere, is that those things that I flagged in these depositions do not represent in toto where I happen to disagree or be at odds or variance. They are just representative of or examples of, and certainly not meant to be the whole.
Okay, understood. Thank you.
Oh, now you just opened up a whole can of worms.
Well, unless you
now
want
I've
me
got
to...
now I've got to ask you. I've got to ask you now.
No, unless you want me to go...
If there's other areas of the deposition testimony of any of the expert witnesses that you disagree with, that you haven't told me about, I need to know now. But I thought I covered that when I asked you all the opinions that you have. So you can straighten me out on that, Doc. Let me know.
Okay. Understanding that the deposition transcripts take up 2 volumes, and he doesn't certainly have them memorized, if off the top of your head sitting here today, you can think of any other criticisms you have of the individuals in those depositions, then you can tell him that.
Objection, that's not my question.
Well,
when I'm going to ask the question, you can object. Here's what I need to know, Doc. I think you already told me. I ask you if you told me all the opinions that you have in this case and intend to give in this case at trial, and that would include any opinions where you disagree with opinions of other experts in the case and the reasons. Now, your lawyer, the lawyer that hired you, covered some of those in her examination. I want to know if there's any other criticisms that you have of any of the testimony that the experts who were retained by Mr. Tolson intend to give. If you have criticisms of their opinions, I need to know them today.
Okay, same objection with the understanding he doesn't have those deposition transcripts memorized. You can answer.
Well, Doc, you have them here at your disposal, so to the extent you don't have them memorized, we can take a 10-minute break and you can go through them. But
okay, it's not going to take 10 minutes, Roddy. Come on, now you're walking us into sitting here all day while he reads those deposition transcripts.
Well, you know,
I think it's fair for him to tell you what he has to say today. Yeah. And certainly his testimony at trial is going to depend on what I ask him, and you know that.
Doc, my question stands.
Did you get my objection, Madam Court Reporter?
We have it now.
Okay.
Sure.
Is it my turn?
Yes.
It is your turn.
You and I have talked about all of the things that I can think of that are substantive in nature today relative to my opinions on this case. My statement to Ms. Dinsmore, I didn't want someone to refer that because there were some things that you and I talked about specifically, that represented the sum total, and clearly from my testimony today, it doesn't represent my sum total of disagreements with what some other experts have said. But I do not have something specific in mind that's in one of your experts' testimonies that I disagree with about that you and I haven't talked about today. I'm not hiding the ball in any way, shape, or form. If there was something else that and I'm sorry I tweaked that concern on your part because I did not intend to. And if there is something that I discovered that I failed to convey to you that I think is substantive, I will let Ms. Dinsmore know immediately. I can't imagine that there is, but sometimes things occasionally pop up.
Doc, did Ms. Dinsmore show you a picture of the steel gate that Mr. Tolson was entangled in?
No, sir.
Did you ask for it?
No, sir.
Did you need to see it?
No, sir, not to do a prospective standard of care opinion. I did not need to, because particularly the EMS thing very clearly described how it happened. So I did not ask to see it, because it seemed like it was something, guy's foot down the ground, got caught, and he twisted and fell. So it did not seem to me to be something, and then I read about a door somehow that was involved, so it didn't seem to be something that I needed to know at that point in time.
And she mentioned the video animation. Did she show you the video animation that we provided to her?
No, sir. The only thing I know about it is what I've read in terms of the questions you've asked, and you certainly described it in a way. I had a visual picture of what it showed, but I didn't see it.
Did you need to see it in rendering the opinions that you've given here today?
No, sir.
Okay. You said that standard of care should not be based on information that is obtained in a later date that's not contained in the medical chart, such as deposition testimony?
Well, I can see how that statement may have misunderstood if that's the way I said it. What I intended to say was standard of care is a prospective thing going forward. Now, if there's information that somebody, just totally neglected that gets talked about afterwards, that would not be included in that. I'm talking about information that is available, reasonably available, someone has, going forward making decisions, but that things that arrive after the fact that represent a much different picture are not applicable to determining the standard of care at the time the original event was described and known.
Right, and what I'm concentrating here is on Dr. Jackson's deposition testimony, where she went into great detail and had specific memory of the evaluation of Mr. Tolson, of the physical evaluation, of the results of the findings and everything that weren't contained in the medical chart. Now, because this wasn't information contained in the medical chart and obtained 4 years later, did you use her testimony at all in reaching an opinion that she did not breach the standard of care?
Objection of form and foundation.
No, not really, because I looked at what she wrote on here, that she agreed with what the PA did and she agreed with the plan, and that was where I went. Now, the fact she said that, it didn't surprise me, because I understand she knew fairly quickly about what transpired with his knee, and when patients tend to have an outcome that is unanticipated, unknown, unexpected based on their presentation, those things often have a way of sticking in our minds indelibly just because of the event that transpires. So it didn't surprise me she remembered that stuff, but my standard of care was based on the records, not including her testimony.
Not her deposition testimony?
No, sir.
Okay.
Although I would say her testimony wasn't at odds with anything. I didn't need it to do the standard of care. I did my standard of care before I had all the depositions. They sometimes fill things in and make things more understandable, or sometimes create a bit of havoc because they disagree. But my standard of care opinions rest on the records that I received.
And you reached, and correct me if I'm wrong, you reached all your opinions with respect to the standard of care of Physician Assistant Shaw and Dr. Jackson based upon the review of the December 3rd, 2009 emergency room record of St. Agnes Hospital. Would that be a fair statement?
Objection of form and foundation. You mean entirely based on the record?
Well,
that's not what he said.
Well, in addition to your experience as a doctor.
No.
But I mean from the medical records.
Well, certainly by and large, there's that original report that was submitted that obviously has far less detail than what we have today. So things get filled in and become more clear and complete. I mean, one thing I was struck with was Dr. Sakhar just sort of dismissing depositions as if they have no meaning. I certainly don't put them in that category. I think they're helpful, and I would read someone's deposition and be willing and want to understand their perspective on things where it may differ with other people. But the standard of care in and of itself, by and large, came from the records. Now, it would also be fair to say it may have been confirmed or corroborated or enhanced by things I learned from the deposition, but not substantively changed.
Okay. And the opinions that you reached on the standard of care for Physician Assistant Shaw and Dr. Jackson were reached well before they were deposed in this case, correct?
Yes, sir.
And you did not rely upon their deposition testimony for the opinions that you've reached that they did not breach the standard of care in this case?
Didn't rely on them, but they helped confirm what my original opinions were. That is certainly true.
But If you didn't have their deposition testimony, your opinions would still be the same, would they not?
That is correct. That's why I say they can confirm, corroborate, enlarge, expand, enhance, but they don't create the base opinions.
Thank you. Let's see. I think it's all I have.
All right.
I'm sorry, I have two follow-up. Wait, Mary Pat, I have two follow-up.
Okay, sure.
Dr. Shank, at the time they were caring for Mr. Tolson on December 3rd, 2009, did the medical providers at St. Agnes have a picture of the gate taken by Mr. Tolson? Did he bring him a picture?
No, ma'am, not to my understanding.
Did they have a video animation created by Mr. Tolson's lawyer in order to, at the time they were caring for Mr. Tolson on December 3rd?
No, ma'am.
Okay, that's all I have. Mary Pat?
Yes, thank you. Dr. Shank, I'm Mary Pat McGuire, and I represent St. Agnes Healthcare, Inc. and Caroline Stell are in this case. Just a couple follow-ups based on the questions you've heard today and answered. Ms. Dinsmore asked you a question a little bit ago about whether you saw anywhere reported in the record, the contemporaneous medical record, that Mr. Tolson made a complaint of a cold foot or that he couldn't feel his foot. And you answered that you didn't see anything with respect to the medical providers. Did you see anything with respect to, in the contemporaneous medical records, that Mr. Tolson made a complaint of a cold foot or a numb foot to any of the nurses caring for him on that date?
No, ma'am.
Okay. And you were asked a long series of questions under hypothetical situations in that event. Am I correct that any re-examination by a physician or PA provider under the hypotheticals that Mr. Gaston gave you regarding a complaint of a cold foot or a numb foot would be expected or indicated if it was an acute change in the condition?
Correct.
Okay. I think that's it. Thank you.
Yes, ma'am.
Are we done? We're done.
Anything further? Hearing nothing further, this concludes the deposition at 3:45 p.m. We are off the record, and this is the end of tape number 3.